Thank you, Judge Gould, and may it please the Court. Mitchell Reich for the plaintiffs. I'll be discussing the justiciability and reviewability issues, and then my colleague Neil Cacho will discuss the merits. This is now the third order the President has issued this year, purporting to ban over 150 million foreign nationals, most of them Muslims, and to dramatically reshape the immigration laws Congress designed. Every time the government's been before this Court, it's made arguments just like the ones you heard my opponent make a few minutes ago.
This is a little bit different, isn't it? I mean, the prior two versions of the executive orders were based a bit on speculation. We've now had a 90-day period in which the government and its agencies, the Homeland Security, the Department of State, et cetera, have gone through, and in part, based on information provided by the past administration, have determined that there are certain countries in the world that you can't tell if person A is really person A. What's wrong with that?
Well, my colleague will get into the merits more, but I think this Court laid out very clearly in its prior opinion that the government had not identified any respect in which the existing case-by-case vetting process is failing. That the burden is on the alien to show they're admissible, and if they can't produce documents sufficient to do so, then they can be denied entry.
Even if the documents themselves are infirm,
the government
historically infirm.
For each of the country bans, the government...
Who would trust Kim Jong-un to say, this person is really this person? You got to take him in.
Well, for each of these countries, the government is allowing many of these people in on non-immigrant visas. So I don't think the government's made the contention, and there's nowhere in the text of the order the government has argued that it's incapable under the existing process of denying entry to harmful aliens. That just finding isn't in the order, and when they purport to show one, they say just that the documents are insufficient. But I think my colleague will get into the merits more. I do want to get onto the justiciability.
What do you propose, and if this is in your colleagues' bailiwick, just tell me, what do you propose as a remedy? That we have a trial in district court?
We think that the record for the preliminary injunction is all that you need to find this order unlawful. We've made allegations. There's no disputed questions of fact here. The order just does not meet what you called the essential preconditions for invocation of 1182F. It does not contain a finding that supports the exclusion, and it does not, under a century of practice, under a century of interpretation, describe a way that these aliens would be detrimental to the interests of the United States. But I do want to address my opponent's... Sorry, Your Honor.
I want you to address it because I want you to address what Mr. Mupon was just saying.
Yes.
Which is that, as I understand his argument, well, there may well be 1331 general jurisdiction. There isn't a vehicle with which to get at these statutory claims.
Yes, Your Honor. And we think we have a clear cause of action here. There's the APA cause of action, and then there's the non-statutory cause of action, which I didn't hear my opponent deny exists as a route to review of the President's proclamation. His argument is consular non-reviewability bars the claims. And I think you should pause on the breathtaking argument you heard the United States government make, and it's in their briefs at page 6. The President can or any officer in the executive branch can, quote, brazenly violate the immigration laws, can ban every alien from the country in clear violation of 1182F, and no court can review that violation. Indeed, they say in their brief, plaintiffs' only recourse is to the political process. And that's not the way the system works, and that's not the way the law of consular non-reviewability has ever worked. And I want to be very clear on this point. For individual consular officers and a fortiori for the President, there is review of statutory violations. My opponent said we can't cite a single case saying that consular officials' violations of statutes are unreviewable. Well, let me cite you one from this court. Rivas v. Napolitano at 714 F. 3rd 1108 said this: a court has jurisdiction to review a consular officer's actions when the suit challenges the authority of the consul to take an action, as opposed to a decision within the consul's discretion. And the case they rely on, their principal authority here is Saavedra Bruno, which was a discretionary decision by a consul. The court emphasized this was a decision wholly within his discretion and a challenge to the sufficiency of the evidence. What we have here is a violation of statute, and in both Rivas and in the case it cites Patel, I urge you to read them, the court reviewed violations of law by consuls and in one case invalidated the visa decision as a result of them. Moreover, this court in Washington and in Hawaii heard the same arguments you heard my opponent make And in both cases, it held that the doctrine of consular non-reviewability has never been applied beyond an individual consular decision to grant or deny a visa. It does not apply to immigration policies. And that was correct. The Washington decision remains binding. And that's true for a number of good reasons. The immigration laws insulate individual consular decisions from review. In 1104A, they provide that even the Secretary of State cannot control individual visa decisions. And in 1201I, they state that a consular officer can revoke a visa at any time in his sole discretion, and that decision is unreviewable. So Congress chose to make individual visa decisions unreviewable. Congress did not choose to make immigration policies unreviewable. And indeed, in Knopf and in Sale, the Supreme Court reviewed those decisions under an order issued under 1182F and its immediate predecessor. I might add, in Sale, in the face of the government's vigorous argument that consular non-reviewability barred the claims, they argued that in their briefs and at oral argument, and no justice on the court accepted that argument, notwithstanding that when consular non-reviewability applies, it's a limit on the court's subject matter jurisdiction, so the court cannot have skipped the question. So I think that the argument you've heard, it's not true of individual consuls, it's certainly not true of the president, and if that was correct, that would be quite a staggering blow to the separation of powers, that the president could essentially usurp the limits Congress imposed on his authority with impunity, and this court would have no authority to review them. I'd just like to touch briefly on finality and zone of interest. I think this court decisively addressed those issues in its prior opinion. The notion that the waiver process renders these claims unripe is simply incorrect. We have detailed declarations by every plaintiff documenting the present harms every plaintiff is suffering, irrespective of the waiver by virtue of this order. 254 of the record, the university can't recruit students. Paragraph 99 of the complaint, multiple speaking events that can't be held. The individual plaintiffs are being separated from their families, and the remote discretionary prospect of a waiver would in no way ameliorate those harms or repair the unequal treatment these plaintiffs are suffering. If there are no further questions on justiciability.
Do you agree that by its terms, 1152A only applies to immigrant visas?
I think the court pointed, I think for 1152A by its terms is limited to immigrant visas. But as my colleague will discuss, since the enactment of the statute, 1 year later, Judge Friendly's opinion recognized that that was a dramatic alteration to the immigration system, that Congress had taken nationality off the table as a relevant consideration. And in Jean v. Nelson, the court said that because nationality is generally a disfavored characteristic, individual immigration officers exercising discretion can't generally discriminate on the basis of nationality. So we think there's a broader principle embodied in the immigration laws. But I'll let my colleague address that.
My question is yes.
We agree on the text that's limited to immigrant visas.
Thank you.
Thank you.
Thank you, Judge Gould, and may it please the court. It's an honor to be before you again. There are 4 separate arguments on the merits. Each explains why the president's unprecedented and sweeping ban is illegal, and each is supported by prior decisions of this court involving Executive Orders 1 and 2. The 4 arguments are, first, under Section 1182, the president has not made findings that support his conclusion that the entry of nationals from these countries would harm the United States. Second, 1182 separately requires the harm to be detrimental to the interests of the United States.
Has to actually use those words?
Oh, he doesn't have to use those words, but I think he does have to do what his predecessors have done and follow the practice, and I'll explain that in a moment. But, it can either be that the individuals themselves are harmful, spies, saboteurs, and the like, or that it's a kind of, at the outer bounds, an emergency situation or something like that.
46 other executive orders on the subject matter have been issued, all contained what you're describing?
Well, I do think that they all meet what I'm describing, yes. And here's why, Judge Hawkins, and this was your question that you were starting to ask my colleague right at the beginning. You said, isn't this executive order different? Isn't there now a worldwide review? And I think that fails for 2 reasons. One is this court, that they have not made the findings that this court called for under 1182. And second, the findings they do make are not the ones that are detrimental to the United States. Let me walk you through that. Maybe just before doing that, let me get the last 2 arguments out, which are the 1152 violation, that's the 3rd problem, the non-discrimination, and the 4th is the First Amendment and religious discrimination. So to answer your question posed to my colleague, here's the problem. Here's what you said in your Hawaii decision at page 773. Quote, although the order explains conditions in the 6 countries lessen their government's ability to share information, the order specifically avoids making any finding that the current screening processes are inadequate. As the law stands, an applicant bears the burden of showing the applicant is eligible to receive a visa or other document for entry, 8 U.S.C. 1361. The order offers no further reason explaining how these individualized adjudications process is flawed, such that permitting entry of an entire class of nationals is injurious to the interests of the United States. Now, that's what you said. It was your clear holding. He then had his vaunted 7-agency worldwide review. Where did they ever find what you called for, which is that the individualized vetting process isn't working? My colleague on the other side just began his oral argument with, I think, these words. He said, this executive order is, quote, a multi-agency worldwide review process. 8 countries have inadequate information that undermines the visa vetting systems. There is zero language in this executive order about undermining the visa systems. They have not made the finding. And this is quite remarkable. You, as the Court of Appeals, said, here's what you have to do, Mr. President. You have wide discretion under 1182. The state of Hawaii is not disagreeing with that. But you've got to make a finding that the individualized vetting process isn't working. And in the teeth of that, what did they come back with? Zero. They've talked about bargaining and diplomacy and information restrictions. But what you said before was, why does any of that matter, the information sharing? The burden is always on the individual visa applicant to come to the United States. And if you can't show any bad folks are coming here, then there is no 1182 finding. Their answer is like to say, well, there's all sorts of information problems there, but the information problems, the identity management problems, the dictator who we're worried about giving false information, as long as the individualized vetting system is working, that's enough. And you have before you again, just as you did last time, national security experts saying exactly that. That's at the excerpts of record at page 55. People like Secretary Albright and Senator Lugar and General Hayden saying that. But I don't think you even have to get to the record or anything like that. You made a clear request, a clear requirement to the government. I mean, when I was in the government, if a court, even a district court, or even some small whatever court said, you've got to make this finding, and then you had a long interagency process, and they didn't make it, boy, that's a dog that really didn't bark. And so, even if you concede everything about, giving wide berth, deferential, and so on, they have not made the finding that this court required. That's the first and I think most significant problem when we deal with 1182.
Were we too demanding in our prior opinion?
I don't think so. I think it's something any president should be able to meet. I mean, Judge Paez, the idea that a president is going to be constrained in some way. No, I think all you said was, make a finding that there's something bad going on, that entry is harmful. And, I do think it's telling that with all of these agencies and all of this review, they couldn't do it. And I think, the national security experts tell you one reason why, which is the individual vetting system is working. But you don't have to get there and have that debate. It's just you made a procedural request, make the finding, they didn't do it. Now, there's also a substantive part of 1182, and that's what your question to my colleague was getting at, which is this bargaining chip idea. Right. And, the bargaining chip, even if you conceded the bargaining chip, that they want extra information and vetting, and I don't think that that's going to qualify, but even if you thought it would, they'd have to first identify again that some bad people are coming into the United States. It's kind of like, those coin sorting systems when you go to a bank and, it sorts out quarters and dimes and so on. And the government is saying, well, the president is saying, well, there's someone throwing in some buttons to the system, some spurious material. Well, that doesn't matter, the input, as long as the filter is working. And what this court said is, it looks like the filter is working. Tell us why it's not, Mr. President. Make a finding that the individualized vetting system isn't working. They have not done that. Now, there's also a substantive problem, as I was saying, which is, that 1182 doesn't, I think, permit the kind of, foreign policy harms writ large that he's talking about here. The text of the statute is the president has defined that the entry must be detrimental. And earlier, your earlier decision in June said, for example, government resources or something isn't entry being harmful. And similarly here, the entry here that he's asserting, this bargaining chip, is not itself it is not itself showing that there's any immigrants right now coming or not, or folks on visas that is detrimental to the interests of the United States. So that's why we think 1182, again, we concede that there's a lot of discretion for the president, and no president has any trouble meeting the standard in the past, and that's what the CRS report says. But this is really a step that's very different. And, if you read the government's brief, you get the view that, presidents do this all the time, things like that. Absolutely not. They've been able to muster, in the 45 or so instances of the president using 1182 over the last 70 years, 2 examples tops, and neither of them is very good for exactly the reasons you said in footnote 13 of your predecessor opinion. Those are exigency, emergency circumstances done to address a diplomatic, retaliatory, fast-moving action, certainly not something like this, in which the president has had 10 months in office, he's saying this is important for national security, and yet he's never, in the teeth of being struck down time and again, gone to Congress and say, hey, set up this vetting system, improve it, do whatever. That's what presidents did after 9/11 and the 2004 Act and other things. Nothing like that here. Instead, he is asserting, and this, Judge Gould, goes to your hypothetical, which I found, his response very telling. The idea that the president can ban all immigration from around the world and this court would be powerless to review it. I mean, his argument is essentially the president can take an iron wrecking ball to the immigration code, that finely reticulated system that Congress has done, and put the president in the driver's seat. That's certainly maybe some constitution. It is not the Constitution of the United States. And Judge Paez, as you were saying earlier to my colleague on the other side, 1182 itself, forget about just the whole INA. His argument would allow the wrecking ball or line item veto over any provision in 1182. Congress has really thought with a fine-grained 10-part reticulated test about excluding people for terrorism, and it hasn't done anything like this dragnet which he is engaged in.
Let me ask you one, just before you shift off this, in just trying to understand how this statute works or should work, and even acknowledging what we said before, if you just stand back and look at it for a moment, to what extent should the court, or how deeply should the court dive into trying to criticize or look at the president's findings?
Right. So first, he's just got to make one that's relevant. So that I do think it's got to actually be the 11.
And in your view, that finding is individual A came into the country through the prior system and committed a bad act.
Well, it doesn't even have to be.
Is it your argument that he can't do it?
No, he can be even a class of people or something like that. But you've got to show that there is an entry that, quote, would be detrimental, not, some hypothetical or something like that. But, and there's a lot of history behind this. Our brief goes through at pages 30 to 39, exactly this history. FDR wanted a broader authority, and what Congress said is, no, we're not going to give you that kind of, untrammeled authority to do what you want. You've got to be, it's got to be people who are injurious to the United States themselves, spies, saboteurs, war criminals, and the like, or possibly at the outer bounds an emergency situation. But this is neither of those, which is what the problem is.
And my other part of this question that I wanted just to follow up on this is, to what extent at all can we look at the president's intent that might be underlying his actions under?
I don't think you need to get into anything about the president's intent here, Your Honor. I think you should ask 2 questions, 2 fundamental questions. One, has the president made the finding that's required under 1182? And second, is of any sort of threat that the 150 million nationals are a threat? And then 2, is that threat detrimental to the interests of the United States in the way that the court, I think, would expect it to be, which is, those 2 categories, and that's what all of the legislative history is about. If I could, maybe I'll turn to Judge Hawkins, your questions about the other argument, about 1152, the other statutory argument. Congress in 1965, and I think that's what this court's predecessor decision in June recognized, did something sweeping by banning nationality-based discrimination. And my friend says, oh, this is what presidents have done all the time. Never, ever, ever has a president done this since 1965. When President Johnson introduced the act at his State of the Union address, he said, echoing his slain predecessor, quote, "A nation built by immigrants of all lands can ask those who now seek admission, what can you do for our country? We should not be asking, in what country were you born?" And effectively, that's what this order does. Now, Judge Hawkins, you said, well, does this extend to everything? The statute says immigrant visas, does it extend to non-immigrant visas as well? We do think it does. That is, as Judge Friendly said the year after President Johnson made the statement, the immigration code is fundamentally altered now. It's altered in a way that says that, you can't have as a relevant factor nationality anymore. And that's what this court's, I think, predecessor decision recognized at the beginning. It didn't squarely reach the question. Last time around, immigrant visas was a smaller percentage of the overall visas affected by Executive Order 2. Now it's a much bigger one. And so even if you disagreed with what I'm saying about Jean versus Nelson and Judge Friendly, this would take out and declare invalid a huge part of the order. And it's exactly the reasons that you found last time around. There is no change whatsoever from Executive Order 2 to 3 when it comes to nationality-based discrimination. Now, my friend has said in response to your questions, well, Congress has still left in place the 1182 power, and somehow that should trump 1152. Sorry, that's the wrong word. With respect to that, I think this court answered that in its last opinion by saying the 1152 is a later in time statute, and it is sweeping, and it admits of only certain exceptions. And one exception is not the president can use 1182 and restore the entire national origin discrimination system that had existed pre-1965. That just can't possibly be what Congress was thinking. Rather, as Judge Paez, you said in the last oral argument, the job of the court is to reconcile two different statutes. And here you've got one statute that gives the president, admittedly, broad powers in 1182. It just doesn't extend so far as to say you can discriminate on the basis of nationality. And indeed, Congress, in its text, expressly said to the contrary.
Counsel, I have a question for you. Assuming, for sake of argument, that we were to accept the government's position that 1152A only applies to immigrant visas and to nothing else, am I correct that the proclamation here would still fall in total because of the lack of a proper detrimentality determination?
Absolutely. So there's two totally different statutory violations. There's 1152, which we think covers everything, but as your hypothetical said, assume we only win, it covers immigrant visas. It would only take out that part of the order, which is a big part of this Executive Order 3. But our other argument about detrimentality in the finding is an 1182 argument, and that stands totally separate, and it does knock out the entire order, just as last time around when you found 1182, it knocked out the entire order. And they just have not met what you said at page 773 with respect to 1182. If I could, maybe I'll spend a little bit of time on the constitutional claims, because I do think that they're important, and I think, Judge Hawkins, maybe to start with, why is this religious discrimination? Last time around, you asked my opponent on the other side, the Solicitor General, you said, has the president ever disavowed any of these campaign statements? And he pointed then to some amicus brief and tried to make that argument. I think the record since that time, since we last met, is really quite telling, because in the interim, we had the Fourth Circuit en banc say that this Executive Order 2 was a violation of the First Amendment, that it was religious discrimination, that it was effectively a Muslim ban. And in response to that, what was the president's action? Was it to do what I think any government official I would have thought would do, which is to say, no, this is not a Muslim ban. That's a campaign thing. I'm not doing that. Does the president say anything like that? Absolutely not. Instead,
the question you refer to was from the hearing on May 15 when we were all here.
Exactly, on Executive Order 2, yes.
And my other question is that in our opinion on 2, EO2, we pushed aside constitutional considerations, made our decision only on statutory interpretation. Why should we change that?
I don't think you...
Or otherwise, your argument is stick with what you've already written.
Absolutely, Your Honor. I'm not here saying that you should reach the constitutional reasons unless you disagreed with us on the statutory things. I think that was the logic.
Did the district court rule on constitutional issues?
They didn't. My only point, though, is if you disagreed with what our statutory arguments are, which I think would require you to, really disregard everything you wrote back in that after that May 15th hearing. But if you did for some reason, then I do think you should reach the constitutional arguments here. They are briefed, they are well developed, and the record has only gotten worse since we last met in May. That is to say that the president has not moved away from his campaign promises and indeed has just issued a new executive order. And you can even look to what was said last week as I think a kind of telling indication of bridging the past to the present and rekindling the past.
Mr. Kutuka, let me take you back to 1182F for just a moment, okay? Suppose that just theoretically speaking, that we didn't think the finding was sufficient. Or we thought the finding was sufficient, I should say.
Oh, okay.
Just looking at it, that gave a reason, and maybe we went too far in our prior opinion and need to step back, but let's just hypothetically speaking. Is there another way in which the president we could rely on 1182?
Absolutely. So as you were saying to my colleague asking about the limited nature of this, that is, the 1182 does have the word suspend and period, and absolutely, I think this court recognized last time around in its May 15th, post-May 15th hearing opinion that the president has to have a rationale that's sufficient to show that it's detrimental to the United States, and as the policy gets longer in time, that rationale has to be better. So, last time around, Jeff, the Solicitor General said, hey, this is only a temporary ban. We only need minimal justification. Now that this is, as you said, a ban of indefinite duration, they do need to justify it with the stronger finding. And that's what the district court here expressly found, relying on your opinion below. So I don't think that even if you were to find that somehow they met the finding that you called for at page 773, they've met the kind of finding necessary to justify this indefinite ban. I mean, again, no president does anything like this. I mean, their closest examples are so far afield. And, of course, the Supreme Court has said even if the president had done this in the past, it doesn't make it constitutional. But they have, or legal.
By way of my question is that at what point do we reach a serious separation of powers situation?
Well, I think if you buy their argument, you're in the separation of powers problem right away because he wants to gut the role of this court entirely. I mean, from our perspective, we understand that 1182 gives the president broad powers, but it does have a procedural and a substantive component to it. They've got to make the findings, and the findings have to be sufficient. And under your hypothetical, they've somehow met that they've made the finding, but it still has to be sufficient. And as that ban gets indefinite, it sure looks like a very hard thing for them to do, given the record that they have adduced in this executive order.
On the issue of indefiniteness, and we could be wrong, but my chambers found 43 orders under 1182 since it was enacted. Only one of them had a time limitation.
Absolutely. I'm not here, Judge Hawkins, saying that the president can't make an indefinite order. I am saying that 1182 contemplates a limited one, a period of limited time, and if there is to be, as this court said last time around, if there is going to be a justification under a finding, as the policy gets longer, that justification does have to be better.
And the proclamation, which requires periodic reviews and reports and adjustment of the policy, from your perspective, that's not good enough.
It's not good enough. First of all, it doesn't even require it because the last lines of the order say there's no guarantee to any of it. So I don't know that it requires it. But I think ultimately the problem is that the finding isn't justified on its own terms. That is, this is not a circumstance in which they said, we distrust individualized vetting or something like that. Indeed, they have all sorts of exceptions for countries, even ones that fail on information sharing and identity management, for individualized vetting. So this is not, a kind of coherent document that says, oh, we just distrust our own processes or something like that. So I think that's the fundamental problem with it. If there are no other questions, I'll just sum up in half a minute or so. Tomorrow it will have been 2 years to the day since Donald Trump called for a complete and total shutdown of all Muslim immigration to the United States. It will also be another sad anniversary, 76 years since the devastating attack on Pearl Harbor. Pearl Harbor led not only to an assault on our nation's security, but also an assault on its most basic commitments. The walls of this very courthouse where Gordon Hirabayashi was tried bears witness to that tragedy. What the government did then in the name of national security did not make us stronger. It betrayed our values. It betrayed our nation's soul. And rather than defend those values, the courts stood by them. Twice now, this court, reflecting the dissents in those cases, not the majority, has made sure not to repeat that mistake and to avoid the nightmare of Judge Gould's hypothetical of a federal court system that is powerless. This court has twice asserted its vital role as guardians of the law and rejected the president's attempt to flout our Constitution, to flout our laws. We ask that this court do so again.
Okay, thank you, counsel.
Your Honors. Several points, Your Honor. The first and most important is Mr. Katyal is absolutely right that this court said last time that the EO2 didn't have a finding that the vetting was inadequate. He is absolutely wrong that the proclamation doesn't have those findings today. And I apologize, but let me just read through the findings just to make clear quite how wrong he is. So from Section 1C of the order, it makes clear that the Secretary of Homeland Security was required to identify whether, and if so, what additional information will be needed from each foreign country to adjudicate an application by a national of that country for a visa. That's what the Secretary of Homeland Security was supposed to find. You then go to Section 1H of the order. The order sets forth that the Secretary of Homeland Security was supposed to provide a list to prohibit the entry of appropriate categories of foreign nationals of countries that have not provided the information requested. And then, and critically, if you look at Section 1HI of the order, here is the President's key finding, which directly contradicts what he said. The restrictions and limitations imposed by this proclamation are, in my judgment, necessary to prevent the entry of those foreign nationals about whom the United States government lacks sufficient information to assess the risks they pose to the United States. I don't know how it could have been any clearer that the proclamation made the finding that this court asked for. You might disagree with the finding, but you cannot disagree that the finding was made. And in fact, he doesn't really argue otherwise despite having asserted it. What he's really arguing is his argument that the entry has to be harmful in and of itself, that the individual aliens have to impose harm. But he didn't respond to any of the points I made about why that's wrong. He didn't respond to the fact that that wasn't true in the Iranian proclamation. It wasn't true in the Cuban proclamation. It wasn't true in any of the other 40-some-odd proclamations, all of which involve people who engaged in harmful conduct abroad, not when they came here. Indeed, he didn't even challenge in this very proclamation the provisions that apply to Venezuela. The Venezuela restrictions apply to government officials and their family members. No one is arguing that their family members are going to engage in harmful behavior in the United States. The reason that restriction was imposed was to deter and sanction foreign officials who had engaged in harmful behavior towards the United States. He didn't even challenge it because that is just simply wrong that under 1182F, the individual has to engage in harmful behavior in this country. That has never been what the statute has been about, and they've just gerrymandered that interpretation now because they recognize that if, as the proclamation finds, the problem here is that there's harms from the foreign governments, and the way we are dealing with that problem is by imposing entry restrictions to encourage the foreign governments to fix the problem. Almost all of their tailoring arguments just fall completely apart.
So why does the proclamation then, with respect to some of the countries, allow for entry of certain categories without any restriction.
That shows exactly the point I was just making, Your Honor, which is...
Explain to me. I don't quite get that.
Because the point of this proclamation, in significant part, is to encourage foreign governments to change their behavior, and that is not a one-size-fits-all decision. It is an intricate and complicated foreign policy judgment, and the president, relying on his advisors...
Just to take what you said, I mean, if you take the statement that you read to us, and link it back to the concerns about lack of insufficient processes for doing adequate identification of who the applicant might be, and you go over to what they did, say, for example, in Chad, the proclamation suspends immigrant visas, suspends business visas, suspends tourist visas, business/tourist visas, but there's no restriction on a student visa, an exchange visitor visa, and other non-immigrant visas. So if they're concerned really about identity, I don't quite, how does that all line up?
As the proclamation explained, Your Honor, the proclamation imposed the strictest sanctions on the countries that were most recalcitrant and imposed lesser sanctions on countries that do cooperate but are still inadequate. Having varied levels of sanctions based on the degree of recalcitrance of a country is a perfectly rational way to encourage countries to perform. More importantly, they have no explanation at all for why those restrictions are the way they are. On their theory that it's a Muslim ban or something else, why on earth are there exemptions? They can't explain that at all, but the proclamation explains exactly why it is that way. It is tailoring the restrictions in a way that the president and his advisors determined were most likely to encourage foreign governments to change their behavior. The third point I'd like to make, Your Honor, is that he's again and again suggested that this is somehow a way of replacing the INA, overhauling the INA. Yet again, though, there was no response to the D.C. Circuit's decision in Aberesk, the First Circuit's decision in Allende, the Supreme Court's decision in Sale, all of which recognize that the president under 1182F can impose additional restrictions over and above what is in 1182A. The fourth point, Your Honor, is on 1152 and nationality discrimination. He said, I believe...
Sale dealt with, that was the case, the Haitians, right, entering, and they were interdicting the boats as they were coming to the United States. Is that correct?
That's right. And in that case...
And the plaintiffs, they were arguing that claims for asylum and withholding of removal should still apply to those individuals who are on their way to the United States.
That's right,
and
Your Honor.
And the Supreme Court said, no, those don't apply until they get to the United States.
Right, and that's exactly the point, Your Honor. The president used 1182F to thwart the Haitians from being able to invoke the provisions they would have been able to invoke under the INA if they had gotten here. Right? If they had
I'll have to go back and read the case, but I don't recall.
That is exactly what the entire fight in that case was. If the Haitians had reached the shores in an exclusion proceeding, they would have been able to invoke all sorts of claims for I believe it was asylum status, and precisely to avoid that, the president imposed a blockade that prevented them from getting to the shores.
The other thing that's interesting about Sale, as Mr. Cattell pointed out, is that the court had no difficulty in reaching the questions that were involved in that case.
That's true, Your Honor, but they rejected the claim. So they
rejected them on the merits.
That's true, Your Honor.
They reviewed the claims, though.
Right, but they didn't say that the claims were reviewable, and they didn't have to decide the issue.
Well, I mean, why would they go to the extent that they did? I mean, they could have just said these are non-reviewable, and we're not going to review it. Out.
They could have, but since they found the statutory issues pretty easy, I think, Your Honor, it was 8-1, and I think that's a pretty reasonable explanation. The fourth point I'd like to make is on 1152 and nationality discrimination. I believe Mr. Katyal said that never, ever, ever has any president engaged in nationality discrimination to deny immigrant visas. But again, that is exactly what President Carter did for Iran, and is exactly what President Reagan did for Cuba, and he, again, has literally no explanation for that. The last point I'd like to make before I sum up is just on consular non-reviewability. They cited a couple of cases. To be honest, since I don't believe either of those cases were cited in the briefs, I'm not familiar with the first one he cited, but I am familiar with the second, which I believe was Patel versus Reno. That case didn't involve an order to require an alien to enter the country. What the court said was that the consular officer had to rule on the visa application. It didn't say that the substantive decision would be reviewable. The last point, and on consular non-reviewability more generally, their scare tactic that this would mean that there would be no review and Congress's scheme could be totally overridden falls apart when you recognize that these are statutory claims. If Congress is worried, Congress can provide a remedy, and Congress simply has not done so. The last point I would like to
You're
make
saying there would be no remedy unless Congress acted, but Congress could act.
Yeah, of course. Congress could, of course, provide a cause of action for the denial of entry to aliens abroad in violation of the INA. The point is that Congress hasn't done so and has never done so, and that is why when consular officers restrict the entry of aliens abroad, even in violation of the statute, there is no review.
Thank you. Now,
I'm
afraid your time, even with the extra 5 minutes, is more than exceeded. So
Thank you, Your Honor.
we better stop. I want to comment really that the advocacy on both sides was exceptionally helpful, and we really appreciate it. Accordingly, the Y v. Trump case shall now be submitted, and we will try to get an opinion out as soon as practical. And I think the Supreme Court has asked us to do that, so we shall comply. Okay, thank you. Court is adjourned.